conversation now. The State Capture Commission held public hearings for more than 3 years at a cost of 1 billion rand. But there is still the matter of court applications to review its report, of course, by those who were implicated. The Commission still dealing with about 12 review applications. Let's get an update now on this, and we'll speak to the Solicitor-General of South Africa, Fhedzisani Pandelani. SG, thank you very much for making the time to come to studio here. For viewers who may not know the role of the Solicitor-General, what is it that your office does?
No, thank you very much for having me, and thanks to your viewers as well. Look, the office of the Solicitor-General, or the Solicitor-General, is a creature of statute.
Right.
It's been created by a statute that has been proclaimed only in 2020, which is, on the onset of the COVID pandemic, if you may.
Yeah.
It oversees offices of state attorney, 13 offices of state attorney across the Republic. It is responsible for management and coordination of all litigation in which the state is involved. It also coordinates the legal work across all government departments, but also does have a role in playing a transformative role in relation to relationship with private legal practitioners in the Republic. So those are the mandates that in fact define the office of the Solicitor General.
Yeah, all right. The interesting bit, which fits in exactly to what we are going to discuss today, is what you are saying, that the office of the Solicitor General is responsible for the litigation in which the state is involved. Let's then talk about the review cases coming out of the State Capture Commission of Inquiry. How many of these have you received and you are actively processing?
Yeah. The last count, actually, there would have been 13. If you look at the publications that were there, the state attorneys were given credit for having required of one of the other applicants to file security for costs, which has not been filed, and therefore we are discounting that one. The active matters that, in fact, I can refer to now on record is about 12. Yeah. So those are the matters that we are seized with as the state attorney.
Is the office capacitated to handle these cases? Do you feel that these will be handled effectively?
Yeah, that's a very critical question. In order to contextualize, the 1 billion odd that you refer to that has been spent during the 3-year tenure of the commission has been spent mainly under the auspices of offices of state attorney. As at that stage, there was no talk of capacity. So if we were able to deliver that mandate during that 3-year tenure by overseeing the briefing of everybody else that in fact appeared for and on behalf of the commission during that period, it does appear that we do have capacity. The state attorney is the biggest law firm in Africa as we speak right now. There are 13 offices of state attorney, excluding the additional attorneys from the road accident fund that is now my responsibility in relation to litigation. We are just under 400 lawyers. There is no law firm across the Republic that has got that number of lawyers. Now, if you talk capacitation, there's quite a lot of litigation against the state. Now, my responsibility is to oversee offices of state attorney as an executive officer, and part of that, strategically, is to look at capacitation. However, there is a need sometimes to outsource or brief external legal practitioners where there is a need. So that question cannot actually just be answered on the basis that state attorneys do not have capacity. Let me give you an example. When the NPA prosecutes, no one says, no, you can't deal with that matter because you are not capacitated. Yeah. When the SIU deals with matters, no one says to the SIU, you cannot deal with these matters because you cannot capacitate. We need to be given time and space strategically for us to make that determination, not for external parties to come and say, state attorneys, all of a sudden, you are not capacitated and therefore this must happen. I think that is one issue that is problematic from the mandate that we all have.
You speak very passionately on this matter, and I'm not sure whether it is prompted by the suggestions that private law firms should be enlisted in order to help the state fight the review applications that are coming out of the State Capture Commission from inquiry, because the people implicated there, these are not small-time people. These are people with deep pockets, and they are going to probably defend this up until, hopefully, their very last cent, but not the state's cent. Again, I ask you the question, is this passionate defense of your office as to whether or not you are well capacitated to deal with these, does it stem from these suggestions that have come to say, seek help from private law firms?
Yeah. Admittedly, the state attorney would never be capacitated to deal with all of these matters. What I'm actually yearning for is the Office of the Solicitor General has the statutory mandate to strategically look at those aspects. It cannot be usurped by people that are influencers out there who say, you know, give these instructions to this one and this one. You know, there is something called a state litigation strategy. And we don't go out there and actually disclose some of the other things that we do. Now, the Office of the Solicitor General is not statutorily a vote carrier. It doesn't carry a vote. So even accepting that I need to give the latitude to any other person to say we need capacity, the vote holders, accounting officers in the various government departments that are responsible for the mandate must actually accede and say we do have the budget. Now, I'm actually putting it out there to say, whilst there is a desire to have external capacitation, you know, to deal with these matters, and of course, I would be the first person to say, you know what, we take the work of the State Capture Commission very seriously. And that is why we were willing to run with it for this long period. You still have the condition precedent that says you need to then get the accounting officer of the department that is impacted, or alternatively, approach Treasury for allocation of resources. Why do you do that? You do that because you do not want private legal practitioners to be roped into these matters. At the end of the day, then there's a dispute with the Office of the Solicitor General because they are not getting paid. So all of those boxes need to be ticked before you, in fact, say you are getting this additional capacity to assist state. It is in fact desirable that in fact we use or utilize all the people that were involved in the State Capture Commission during that period to be part of us. There is no doubt about that. When you talk about additional capacity that can actually be gotten from the private legal practice, you also need to look at the issue of resources. Do you have resources, or are you just ticking the boxes of saying you want to aggrandize this space by having these additional people, when in fact you might not even be able to pay for their fees and services? We spend 1 billion rand. How much would we be spending by getting these people? So we do need capacitation in that space. One cannot clown around and say state attorneys will wake up one day and be able to deal with these matters. They are already dealing with almost 370,000 active matters as we speak right now. So they are flat on their foot. So we do need that additional issue. But the condition precedent relating to payment of these services must actually be dealt with and addressed.
Is there money? We don't have time. Is there money to deal with these cases? You're saying there are about 300 of them that you are dealing with.
No, right 370,000 matters are matters that we are dealing with as state attorneys actively, as at the moment.
Right.
Yes.
But it's not specific to
it's not
the
related
state capture.
to the state capture matters. Those are only 12.
I'm specifically focusing on state capture because the commission seems very impatient about the pace at which these cases are being dealt with. I mean, for starters, there's just one right now that we are all aware of that is ongoing, and that's the one in Bloemfontein. It's just one.
So, Colleen, as I indicated, I don't carry a vote. When there is a need for consumption of state legal services, we rope in the assistance of accounting officers to avail resources to deal with these matters. In relation to the particular matters, we have had various meetings, and there are ongoing engagements between the Commission itself and the Department of Justice and Constitutional Development for availability of resources strategically to look at the weaknesses inherent in the management of the review applications. For the moment, we have in fact filed all notices of intention to oppose in all of the matters. We have roped in people that were engaged with these matters at the time when these matters were serving at the Commission. What remains is, do you then wake up one day and find a legal practitioner knocking at the door of the state attorney saying, I want all these records because now I'm mandated to assist the commission. Strategically, that is in fact something that is problematic in this space.
Final question to you. For people that followed that commission closely, if there is one group of people that needed to go there, but they didn't because they sit elsewhere, and in all probability they sit with bags and bags of money, what is your role as the Solicitor General to help the state? As you say, your job is to coordinate wherever that the state is involved in matters of legal issues. What's your role in trying to bring back the Guptas here? Do you play any role in that?
From a litigation point of view, yes, we do. We assist, in fact, with the availability of, or identification of fit and proper people that could be able to play that role. Yeah. But fundamentally, the mandate resides within a certain unit from the Department of Justice and Constitutional Development. So that is where we are. But we do meet as senior executives strategically to deal with these matters, in the same way that we do meet strategically to deal with matters and approaches that we should be invoking in relation to the State Capture Commission. And it is our fervent desire that we should be able to find each other. Instead of actually, putting all of these things in the open, it seeks to defeat the ethos of strategically defending the interests of the state. So our wish is that we cannot actually, compromise the work of the commission over the years. You have just hinted on the fact that there are money bags that are sitting somewhere else, probably what we call lawfare, intended to implode the state. We also need to respond appropriately. It's very easy to put any other person under the bars, especially when you talk about an emotive issue such as state capture, because immediately when anybody starts saying, we're looking for resources, we're not finding resources, and you go on mentioning names of people, what you are creating unwittingly or wittingly is that these are individuals that are actually standing on my way, and therefore they seek to implode the work of the commission. What we seek to do as the state is to strategically manage these matters. It can't be that, in 1 week we are given credit for having dealt with one of the applicants, and on another week it is raised that you are in fact raising problems. But our wish is that we need to in fact meet and deal with all of these issues, and we're working on these matters as we speak and as I sit right now.
All right. Fhedzisani Pandelani, let me thank you very much for your time. He is the Solicitor General of South Africa. He heads up that office established in the year 2020.